Sir, the bill before the House amends the Constitution to create frameworks for the President and ministers to take on international appointments in their private capacities if the national interest so requires. If the President were to serve in these international bodies purely in his official capacity, then he would be limited to representing the official Singapore position in everything he says. That would not be in keeping with the requirements of these organizations, nor would it be in the interest of Singapore for our President to be so limited, as it restricts our ability to shape global conversations and initiatives. From Singapore's perspective, there is value to have the President represented on these international bodies. It enables us to be plugged into global conversations and to understand and help shape the thinking that takes place in these important and influential international bodies. But for this to happen, the President must be able to function credibly in these international bodies by lending his expertise to advance the agenda on broader issues of concern to these organizations. So we are presented with a novel issue. Should the President now be allowed to contribute independently in his private capacity when he takes on these international appointments? That's what this issue is about. Cabinet considered this carefully, and we concluded that President should be allowed to do so, to contribute in these international appointments in his independent and private capacity, as this is beneficial for Singapore. Such an arrangement would then enable the President to take on appointments that help to expand Singapore's influence and networks while acting independently on these international bodies. The Attorney General, however, advised that such an arrangement is currently not clearly provided for by the Constitution. And that's why constitutional amendments are needed to enable the President to take on roles where he acts independently in his private capacity. Article 22Q1 will enable current and future presidents to accept international appointments in their private capacities subject to 3 conditions. First, the President cannot contravene the disabilities imposed by Article 19A1, which include a prohibition on active engagement in commercial enterprises. Second, the Cabinet must assess and advise the President that it is in the national interest for the President to accept the appointment. And in making this assessment, Cabinet will be guided by similar principles as those I set out earlier. And third, the President, acting in his discretion, must concur with the advice of the Cabinet. The President cannot accept an international appointment in his private capacity outside of the framework set out in this article. Article 22Q2 will enable the Cabinet to advise the President on his execution of such a role so that it is in our national interest, including ensuring that it does not undermine the President's status as constitutional head of state or contradict the President's powers under the Constitution. The President must act in accordance with any such advice. As a general rule, the Cabinet will advise the President against commenting on domestic politics, laws and policies, against making any commitments on behalf of the government or Singapore, whether formally or informally, and against retaining any remuneration or benefits in connection with the appointment. Subject to any advice by the Cabinet, the President may act independently in his private capacity. Article 22Q3 goes on to require the President to relinquish an international appointment if so advised by the Cabinet. And finally, Article 22Q4 requires the acceptance or the relinquishment of an international appointment to be published in the Gazette. This Gazette notice will include the term dates of the appointment.